welcome to another Law Society of Yukon webinar. This one called Red Flags and Musings, the intersection of immigration law and other areas of practice, namely business law, employment law, family law, and criminal law. Today's presentation is to last for the next 90 minutes until approximately 1:30 Whitehorse time. And my name is Tom Elliott, and I'm a member of the Law Society, and I welcome all Law Society members, wherever you may be, whether that is in Whitehorse, elsewhere in Yukon, or perhaps in some other province or territory. I'd like to acknowledge that this presentation is being broadcast, of course, from Whitehorse, and we are in the traditional territory of the Kwanlin Dun First Nation and Con-Quachin Council. A few housekeeping matters just before we get going. We have quite a few participants today, and from a variety of places, over 50 participants. I will be monitoring the chat room, and for questions or comments for our presenters who would prefer to have those questions come to them at the end of their presentation. So I'll keep an eye on the chat room. Please note, of course, that like most webinars, this webinar is being recorded. And of course, you should see on your screen a PowerPoint slides that go on for some period, for some number of pages. For the moment, I think that is all the housekeeping matters we have. So let me get right to introducing today our two speakers, Rowan Fisher and Amna Bhatti. And I'll begin with Rowan. Rowan joins us today from Calgary, the very warm Calgary. And Rowan is, as you'll see from the material that you received in advance, she is the founder and managing lawyer at Fisher Law, which has a number that operates from a number of locations, both in Canada and beyond. She's very involved in the bar in Alberta, as well as other activities. Please note that Fisher Law is, tell your friends, tell your colleagues, the Fisher Law is running a pilot pro bono immigration clinic in Whitehorse as a way of starting to build a bit of a client base here in this territory. So please let people know that, because with Whitehorse and Yukon's burgeoning population over the last 20 years, so many people moving here from all over the world, Asia, the Middle East, of course, Europe, even South America. There's a great need for knowledge of this area. Anyways, that's a bit about Rowan. Amna, let me speak to Amna. Amna's a counsel with the Yukon Human Rights Commission, and she's also practices immigration and refugee law with Fisher Law. She has a master's degree in law from Osgoode Law School, and she's done some very interesting work in the past, including being legal advisor with Lawyers for Human Rights in South Africa. I'll leave the rest of the background of our presenters today to you to peruse. And at this point, I would like to turn the screen over to Rowan. Take it away, Rowan.
Great. Okay. Thank you all very much. It's wonderful to meet you all. Amna, can you see those slides okay? Yes, great. Okay, so we are ready to roll, which is wonderful. Thank you very much for having us here today. It's wonderful to be speaking to the Yukon Bar and so many others who may be attending this afternoon. We are active in the Yukon with Amna in Whitehorse, and she is supported by our entire team. So we are a group of international lawyers, internationally trained lawyers and immigrants. Our home base as far as headquarters is in Calgary, but only 2 of our lawyers are actually here. We are also located, of course, in the Yukon and then also in the Middle East. So we speak a wide variety of languages, and many of us, well, all of the lawyers and many of the staff have immigrant experience ourselves. A lot of us came with our families here. Some of us came as teenagers, and some of us came just within the past decade or less. So it gives us a really interesting perspective on the work that we do and how we do it. We have a full base practice, which means we do business immigration and personal immigration, as well as refugee work. And we work with clients from outside the country, hoping to come here with their businesses, open a business, or come and work. And we also work with people inside the country who are having status issues, difficulties staying here due to removal orders, perhaps inadmissibility or other kinds of problems. And we help with those as well. So everything from first instance application to litigation to bringing corporations into Canada, we do everything and anything immigration. Today, we are going to look at the intersection of immigration law with other areas of law. We have given this presentation before to many other bars because often in practice, lawyers will encounter immigration situations that are sort of adjacent to what their actual work is with their client, and they're not really sure what to do. Or sometimes some lawyers don't even know what to listen for in order to think, okay, maybe this person actually needs an immigration lawyer and some immigration advice. So the purpose of today is to basically go through 4 key areas of practice that we see a lot of overlap between different practice areas and our work. And kind of talk through some of the red flags and some of the things you can listen for, and basically give you a really general overview of some of the sort of basic concepts of immigration and how it might be impacting your clients specifically. So the kinds of things that really help us when we're working with criminal lawyers, family lawyers, business lawyers, employment lawyers, also tax lawyers, there's also other practices of law, of course, that immigration can touch on, is if the lawyer has asked some really great preliminary questions. So what is the client's status in Canada? If you're getting an indication or if you know that someone is an immigrant in Canada, one of the first things that might be useful to ask them, especially if there might be an immigration issue sort of rearing its head, is what is the client's status in Canada? Because if you guys reach out to us, that's one of the first things we're going to ask you. What is their status? Do they have temporary status? Do they have permanent residency status? Or are they citizens of Canada? And immigration law, of course, can impact all 3 groups. Is their status expiring or does it expire? Sometimes we're working off very, very tight deadlines, and we have to get the file started as soon as possible because perhaps different government agencies are providing people with deadlines, and we want to get in there as early as possible. And so the expiry becomes really, really important. So knowing something about the expiry dates or any information that the government has given your client about immigration is great when you reach out to us just as a preliminary outreach. But let's get into some of the practice areas and where we see some overlap and basically how your clients might be navigating their matter with you under an immigration lens. So the first thing we're going to look at is business law and hiring international workers. This is really, really common, of course, in the Yukon, especially in certain sectors. So if you're looking at hospitality, if you're looking at agriculture, if you're looking at natural resources, retail, all of these are very high volume international worker industries. So it's really important for businesses to start look at numbers and being realistic about the planning, so that you all know for your clients, there are a lot of delays right now in immigration. Things are taking a lot longer than they used to. So doing pre-planning, getting out ahead like in any area of law, of the problem before we see it, or starting on a project or an application well in advance, of course, is always going to serve your client a lot better. There are multiple programs available for companies who want to hire foreign workers. So some of these are regionally specific, so either provincial or territorial programs, and some of these are federal programs. They all have different requirements. So when clients start talking about immigration and talking about workers, bringing workers in, you want to make sure that they understand there may be many, many different options available to them, depending on their business, who they are, and who they want to hire and where they want to hire them from. So there may be many options besides just one they might have heard of from another colleague or another business owner. Strategic frameworks, obviously, we're going to be looking at acquisition and retention strategies using immigration to kind of support both trying to get the best workers a business can get from overseas and also keeping those workers for as long as possible. And that's something we assist and talk to clients with quite a lot. Yukon, we're not going to turn you into immigration lawyers today. Don't worry. This is a 1 hour super hit, but we want to make this presentation available to you afterwards. So we wanted to do some fairly sort of nice bullet points for you. But the Yukon nominee program is where an employer in the Yukon is a PR and citizen and is operating an office in the Yukon for over a year, and they want to then hire someone. There's a lot of criteria. There's a lot of rules. There's a lot of what you can and cannot do as an employer. And so ensuring that your clients know that this is a process, it's a procedure, it will take some time is very, very important just to set those client expectations up at the beginning. There's also a Yukon community program that's really designed for seasonal workers outside of Whitehorse. However, if your client is inside Whitehorse, they can also apply for this as well. It is an employer-driven program. The application is done and the nomination is done of the employee by the employer. So it's important to kind of steer your clients in the direction of it is possible to bring in international workers. There are Yukon programs and there are federal programs, and there's very, very different criteria for both. There is also a Yukon PNP investor and entrepreneur program. You will have clients who are perhaps from overseas themselves, but are PR and citizens in Canada, but have colleagues, friends, family, past business associates who are really interested in bringing business into the Yukon. And this means basically buying into or opening a new business. There's very, very strict requirements for this, like there are for all the business programs. You have to have a net worth of $500,000 with 300 in liquid assets. That's a baseline. That's the bottom rung. So again, when you're looking at high value clients, when you're looking at clients who might want to come in, there are some fantastic resources on the Government of Yukon website to do with immigration and the criteria. Otherwise, of course, throw them our way and we can take people through, what might be the best option for them, whether it's territorial or whether it might be federal. The federal programs, a word you're going to hear is LMIA, and some people call it LMIA. This is the government certification for your employer client to be allowed to hire foreign workers. So it's very important when you're listening to clients and they're like, yes, I want to hire a foreign worker. It's like, great, okay, you are going to have to go through either a process through the Yukon government or a process through the federal government, even before you start even thinking of hiring a foreign worker. There are so many steps and hoops to LMIAs and the Yukon program. You want to make sure when you hear that from a client, we need to fill a labor shortage, that right away the mind goes to, okay, Yukon programs, federal programs, there's a lot here. Here are some resources for you. And that's really what we want to provide you today is some resources for your clients. There's also other federal programs that are involved with specific streams, so specific types of workers. So for example, if you're working with people who are perhaps in the engineering field, all kinds of like IT and systems analysis kinds of things, there's very specific programs for things like IT, especially in Canada. So if you're dealing with a lot of IT clients coming into the Yukon who are looking at working in that field, either in mining, in agriculture, in any other industry, but in the IT field, there are some really specific streams that can be used for them as well for immigration purposes. The International Mobility Program basically is the idea of other ways of bringing people in without LMIAs and without other kinds of provincial or territorial programs. One of these includes opening a business, a subsidiary, or a branch of that business in Canada. So the company is already existing and operating overseas, and they want to open a branch in Canada. That is called an intra-company transfer. So that is also possible for clients of yours if you have some interest from people overseas who want to open a branch of an existing business. Heads up though, this requires a lot of documentation, a lot of tax documentation and corporate documentation, which some businesses in some countries do not have. And it takes a little bit of navigation on how they may be able to apply without what we consider very normal corporate documentation. PR programs. A lot of people focus on temporary foreign workers. They focus on bringing workers in from overseas on all kinds of temporary permits and temporary programs. But don't forget, for higher skilled and high wage workers, you might be able to bring in the people you need directly as permanent residents. This is a fantastic thing to be able to do for clients, because then they don't have to go through the whole temporary process before they apply for PR from inside Canada. They actually land as permanent residents. So we take the time to evaluate clients to make sure we know whether or not temporary residency is really the way to go through territory or federal programs, or whether perhaps a PR program might be more appropriate. The recruitment and retention benefits is something we talk to our employer clients a lot about. Because they're going to be bringing in workers from overseas, there are ways to support workers that will then bring them here, but also have them stay. Employers will often tell you that they have concerns that if they hire someone from overseas, that person's just going to go home, or that person's just going to get another job. This may be true in all kinds of jobs that people think as temporary, and they think of them as a launch pad for their career in Canada. But if you have skilled workers coming in who you are able to support all the way to permanent residency, we find with our employer clients, they end up with really, really loyal, dedicated workforces who want to stay with that organization. And this includes things like providing English lessons, connecting them to organizations that can help with resettlement, not just the immigration side, but the resettlement side. How do you get mortgages? How do you do banking? How do credit cards work? How do I take a bus somewhere? What do I do to get a bus pass? I mean, whatever it is, you can, as an employer, of course, really, really help people do this. So it's interesting when you're having conversations with your clients as to what their plans are. How they plan to keep clients is also something that can also have a really nice conversation piece around it. A lot of PR programs require 1 year of temporary work inside Canada, and by far the majority of low skill or low wage workers come in through a temporary residency program and then apply for PR afterwards. So depending on your client, depending on whether they're a worker, depending on whether they're an employer, there's lots and lots of different platforms that they can start thinking about and frameworks they can start working with you on as far as within their corporate structuring. So the another side of where we see a lot of sort of overlap between us and other kinds of lawyers is with employment lawyers, especially those employment lawyers that are really helping workers navigate problems within their organizations, navigate leaving work, navigate all kinds of issues that might impact immigration. A lot of the temporary work permits are closed work permits. Temporary work is, of course, as I said, very, very predominant in these kinds of industries: manufacturing, cleaning, home care, hospitality, wherever we need lots and lots of people to do often what is low wage or what they call low skill, which is a bit of a misnomer because some of this, of course, is incredibly highly skilled work. So if you are working with clients within these sectors, There are certain challenges immigration-wise because there's going to be so many temporary workers within that workforce. Closed permits means there are specific conditions on the permit that do not allow workers to change their employer, to change their days of work, to change their hours of work, to change their location of work. And if they do these things, they are in violation of their permit. They can be out of status and therefore removable from Canada. So when you're working in the employment sector, you want to make sure that you're keeping an eye out and an ear out for people talking about moving jobs, changing jobs, that their location got changed by their employer, that their hours or days of work got changed by their employer. And if your employer, be very, and your client is an employer, they need to be really, really careful how they're moving their employees around, how they're changing elements of a job offer or a contract for that worker. Open work permits are a little bit different. So the key to listen for is open or closed permits. Open work permits means they can work for anyone. There are not the same restrictions. They are still temporary residents and not permanent residents, but they can actually change jobs very easily. One thing they need to be aware of is if they change their job title, if they change the type of job they're doing, it may not then count towards their 1 year of necessary work coming into permanent residence. They have to start again at zero. So if you have employee clients who are thinking of changing jobs, who have been fired, who have been dismissed and laid off or anything like that, and they are temporary foreign workers, it is really important to ask just a couple questions. What kind of work permit do you have? Are there any conditions on your work permit? Maybe you should talk to someone about this. Okay. Watch out for expiry dates. Again, that's the most important thing with your clients as an employment lawyer. If you can have a peek at their work permit and see when that expires and make sure they're not getting even close to that. We want to do renewals, changes, and fixes on work permits at least a month in advance of expiry dates. So if you have a moment to check for your employee client an expiry date. And for those of you who's working with employers, we do a lot of advisory services with employers, how to set themselves up for success for this, so that they are able to assist their work team to be able to keep track of their expiry dates, keep track of movement of workers between jobs, so they're not in violation of a permit. And so an employer doesn't end up actually losing workers. Vulnerable workers. So there are special permits for workers who are being abused at work, who are under the LMIA Temporary Foreign Worker Program. And what this means is that instead of having to leave work because something horrible is happening and losing status, because now they're in breach of the closed permit, right? We're still talking about closed permit workers. Basically, they don't have to now leave. They don't have to lose their status, because on a closed permit, remember, if you leave your employer, that is a violation of your work permit. However, in cases of abuse, there is a bridging work permit that can help people to leave one job and find another one. They're generally 6 months in duration, and sometimes they can be extended. It depends on the situation and what's going on. So we're going to keep all questions to the end for all of you employment and business lawyers in the room. If you have some questions, please note them down. We'll take them at the end, after Amna has a chat with us about family law and the intersection of immigration law and criminal law and the intersection with immigration. So Amna, take it away.
Thank you, Rowan. You finished your section in less than 30 minutes, so hopefully I have a little bit more extra time. So starting with the first slide, a Canadian citizen or permanent resident can sponsor certain relatives to come to Canada. Sorry, this is the next, okay, to come to Canada. These relatives can be your spouse, your common law partner, a dependent child who's under 22 years old, adopted children, parents and grandparents, and other relatives in certain circumstances. When you're sponsoring someone to come to Canada, you have to sign an undertaking, which means that you are promising that for a set period of time, you will support the person you're sponsoring financially, and you will make sure that they don't need social assistance from the government. There's also a sponsorship agreement that is signed between the two parties, where the person who is sponsoring says that they will provide for the person who's being sponsored their basic needs, and the person who's being sponsored promises that they will make every effort to support themselves. Sponsors are still financially responsible even if there are changes in circumstances. We can go to the next slide now, Rowan. Thank you. So a sponsor is financially responsible even if the relationship with the person that you sponsored changes. For example, because of divorce or separation, the person you sponsored becomes a Canadian citizen, your financial situation gets worse, for instance, you lose a job, or you request to withdraw your sponsorship application after the person you sponsored has become a permanent resident. So when someone who has been sponsored is in a situation of violence and they have permanent resident status, what are their options? If you can go to the next slide, Rowan. Thank you. So a person with permanent resident status cannot lose that status or be forced to leave Canada only because they leave an abusive relationship. This is true even if their abusive partner sponsored their PR application. So a sponsor cannot simply cancel the applicant's permanent residency. But immigration authorities may investigate if a sponsor tells them that the relationship was not genuine, or the sponsored person left out important information or included information that was not true when they made their application to IRCC. So there are many reasons, of course, why someone would not disclose that they're in a situation of violence or family violence. And this is why it is very important for lawyers and aid workers to keep in mind when they assist someone who are leaving a situation of violence. So it may not be safe for someone to continue to receive financial support from their sponsor in a situation of violence. And they may be scared that, if they don't have sufficient funds and their status is dependent on the person who sponsored them, that the status may be compromised and they would no longer be able to work or obtain paid work in Canada. So if someone was sponsored by their spouse or partner to come to Canada, they cannot sponsor a new spouse or partner until 5 years after the date which they became a permanent resident, even if they are legally separated or divorced from their sponsor. So this is also something to keep in mind, because this was actually implemented to avoid non-genuine marriages and relationships being used for immigration purposes. So one must keep in mind as a lawyer that if someone's just come to Canada as a person being sponsored, they'll have to wait for 5 years to sponsor someone else, even if the relationship's ended. Leaving a situation of violence if you have temporary status. If a person leaves their sponsor due to a situation of violence and they have not yet received their PR status, but they have temporary status in Canada as a worker, student, or visitor, they will be allowed to remain in Canada, but they should ensure that their status does not expire. Like Rowan said, it is very important to make sure that your clients, whatever their immigration status is, like they're legally in Canada and that their status is not expiring anytime soon. It is also important to note that a person cannot work or study without a work or study permit unless an exemption applies. So this basically means that visitors cannot work or study. And where a person was previously financially dependent on their sponsor, leaving a situation of violence may be harmful to their ability to survive in Canada. Can we go to the next slide? Thank you. So leaving a situation of violence where you don't have status. So if a person leaves their sponsor due to a situation of violence while their application is being processed, that person will no longer be eligible for PR status. Unless they have an existing temporary status, such as a worker or a student, they will have no status in Canada and may be forced to leave Canada. So it is important at that point to explore the possibility of restoration of status as soon as possible. There's a 90-day limit on doing so. If the 90 days pass, the applicant must leave Canada and then reapply from outside the country. If a work permit expires, the person must stop working. If a study permit expires, they must stop studying unless their restoration is granted. It is also important to realize that a sponsor may have threatened to withdraw their spouse or partner's sponsorship application, which is a common control tactic. And withdrawal of an application can happen at any time up until a decision is made by IRCC. Go to the next slide. So temporary resident permit for victims of family violence, it is a special permit to stay in Canada, and it can also be extended to any children that you may have who are inside Canada. It is important to know that family violence, especially for this permit, is not just physical violence. It can look like, of course, physical abuse, including forcible confinement. It can look like sexual abuse, including sexual contact without consent, psychological abuse like threats or intimidation, financial abuse, including fraud and extortion, neglect, for instance, not providing necessities of life, such as food, clothing, medical care, shelter, and anything that may also be extended to any children that the person you sponsored may have. So emotional neglect, educational neglect, or inadequate supervision. One thing to note is that the person who is making this application does not have to testify against their abuser, and there is no fees to apply for this permit, and also no fees if you want to apply for a work permit in extension of this. So there are very specific situations and sort of a last resort where you can apply under a humanitarian and compassionate grounds application. You can apply for permanent residency. So a person in a situation of family violence may also be able to apply for a PR based on, we call it H&C applications. If they do so, they must clearly describe their situation of abuse in a detailed cover letter for their application. They must also mark the outside envelope containing their application with the letters FV to help IRCC quickly identify their application and be able to prioritize it. So if you have a client that you're helping and they're thinking of applying for this, make sure that their envelope with their application is marked FV. So who can apply? So if you're in Canada and seeking PR, which is dependent on staying in a genuine relationship with an abusing spouse or common law partner, you're a foreign national who can't be assessed for PR because your abusive sponsor has withdrawn their application, you've been falsely told by an abusive spouse or common law partner that they have submitted an application, a family class application, and it is in process, but in fact they have not submitted an application, or you're a temporary resident who wants to apply for PR through a genuine relationship, but that relationship becomes abusive and you may not yet have an application in process. These are the situations in which an agency application may come in handy and will be very helpful. Also note that agency applications can take a very long time to process. So apply for a temporary resident permit stating that you're applying for an agency and a client needs to stay in Canada for whatever reasons while the agency is being processed. Again, this is information that will be most helpful for immigration lawyers who are helping clients that are tangled in family matters as well. But these are just some things to note in case you're assisting a client of yours that is not represented by an immigration lawyer. So can we go to the next slide? So what happens to one's immigration status if they're divorced from the person who sponsored them in Canada. It is important to note where that immigrant is from, because divorce in some countries may be illegal or extremely difficult, take a long amount of time to get an effect, or may not be realized if it is finalized outside that country. In any event, evidence of a divorce is often required, and not only for family law entitlements, but to regularize status in Canada as well. So in a spousal sponsorship, the sponsor and the applicant cannot be the spouse of anyone else, because that will void sponsorships. So polygamy or bigamy, simultaneous multiple marriages is illegal in Canada. So being divorced with your other partner may be essential for obtaining immigration status. If there is no formal divorce, the criminality of a spouse to whom a foreign national is still legally married may make the applicant inadmissible, even if they have been separated for years and have lost track of each other. So any inadmissibility that is applicable to your family members, like a spouse, can still harm your chances of getting status in Canada or staying in Canada. And we'll go over admissibility and criminal inadmissibility under the criminal law section. There are specific legal steps that can be taken, including in family violence situations, but these must be taken early and quickly to avoid removal. In countries where divorce is not recognized or only recognized under specific circumstances, this may lead to a situation where if a divorce is granted in Canada, spousal support arrangements involving foreign property or investments may not be available. Some countries only recognize divorce proceedings in their own country. So should a person from one of these countries divorce in Canada and then get remarried, they may be committing adultery in their country of origin. And where in countries where the penalties for adultery are severe, it may be dangerous for those divorced and then remarried in Canada to return to their homeland, even to visit. So these are some things to consider when speaking with your clients who are immigrants and getting divorced. Let's talk about spousal and child support in these situations. So in countries where a contract for a payment of money or other considerations such as land or jewelry is made upon marriage, so in a lot of Muslim cultures, that's the meher. Canadian courts may take these contracts into consideration in deciding support arrangements. So courts may enforce agreements and contracts made outside of Canada and ensure their provisions are included in the orders that are given. So it is very important to discuss any assets like property or investments or gifts or legal arrangements made in the past in any country. Courts have given significant consideration to whether the applicant will need to depend on social assistance should spousal support not be granted. When a sponsorship agreement is in effect, it binds the sponsor to provide for the applicant, as discussed. So court there may see the economic, professional, and personal losses of an applicant in joining their spouse in Canada as a reason to grant spousal support. However, where an applicant has not met their obligation under the sponsorship agreement to make efforts to become self-sufficient, or the marriage is found to not be genuine, or there has been misrepresentation, spousal support may not be granted. Let's talk about criminal law and immigration. So, we can start with the first slide. Thank you, Robert. Some people are not allowed to come to or remain in Canada. They're defined as inadmissible under Canadian immigration law. And there are many different reasons why a person can be found to be inadmissible, such as misrepresentation, security, criminal history, medical reasons, etc. And in the next slide, we'll discuss the types of criminal inadmissibilities. So, an immigration officer decides when you enter Canada if you can enter and then apply for a visa or an electronic travel authorization, an ETA, or also when you arrive at a port of entry. If you are found inadmissible, you'll be denied the visa or the ETA, refused entry, or even removed from Canada if you're already in Canada. So you can be found inadmissible for several reasons. Security reasons like espionage, violence, or terrorism, membership in an organization which is involved in war crimes or crimes against humanity, or if you were a senior official in a government engaged in gross human rights violations and subject to international sanctions. You may be inadmissible if you're found that you have committed a crime, including driving while under the influence of drugs or alcohol. Organized crime, such as membership in organizations that are involved in criminal activities, people smuggling, money laundering. You may also be found inadmissible for non-criminal reasons like medical reasons, if it is found that you could endanger public health or safety in Canada, or that you could cause excessive demand on health and social services in Canada. There are some applicants that may be exempt from this. Financial reasons, like we discussed, if you're unable or unwilling to support yourself and your family members. So when I got my permanent residency, I promised that I'll try my hardest to support myself and any family that I may sponsor. Also, when I became a Canadian citizen. Misrepresentation. So again, providing false information or withholding information. And like we discussed, if a family member, a past spouse, partner, if they're inadmissible, you may be found to be inadmissible. Which is why, again, it's really important to get divorced, like a formally divorced. So another situation where you may be found inadmissible is if you have failed to comply with any provisions of the Immigration Act. So, for instance, temporary residents who don't respect the conditions of their stay, like they're working without a work permit, studying without a study permit. Permanent residents who've lived in Canada, who have not lived in Canada for the required amount of time, so they've not met their PR requirements, or people who have been previously deported and tried to enter Canada without written authorization, or again, like important to note, if you've been convicted of driving while impaired, you may be inadmissible to Canada for serious criminality, and we will go over serious criminality and criminality in just a little bit. Determining criminal inadmissibility. So in general, temporary residents and people applying for permanent residency are considered to be criminally inadmissible if they were convicted of an offense in Canada. They were convicted of an offense outside of Canada that is considered a crime in Canada, or committed an act outside of Canada that is considered a crime under the laws of the country where it occurred and would be punishable under Canadian law. So in order to determine inadmissibility, foreign convictions and laws are equated to Canadian laws if they have occurred in Canada, as if they have occurred in Canada. There are some situations that need to be considered for which you may not be found to be inadmissible. For instance, for charges which have been withdrawn or dismissed. So if the offense occurred in Canada, you're not inadmissible. If the offense occurred outside Canada, you may be inadmissible. For an absolute or conditional discharge, if the offense occurred in Canada, you're not inadmissible. If the offense occurred outside Canada, you may be inadmissible. If you've been granted pardon, if the offense occurred in Canada, you're not inadmissible. If the offense occurred outside Canada, you may still be inadmissible. So if you may be inadmissible, you must provide an immigration officer with complete details of all the charges, convictions, court hearings, copies of any sections of foreign laws that are applicable, so that the immigration officer can determine whether or not you are inadmissible in Canada. Because like I just went over, there are so many sort of situations and caveats that may make you inadmissible or admissible in Canada. So the act that governs admissibility or inadmissibility is the Immigration and Refugee Protection Act. Sorry, we call it IRPA. So Section 36 basically describes what is serious criminality, and then the subsection 3 of Section 36 describes how serious criminality or criminality may be governed. I'm not we'll go over what serious criminality means because it can impact your chances for appeal or your rights to appeal, but I'm not going to go over these sections independently. You can read them online if you like. So you don't have a right to appeal at the Immigration Appeals Division if you have been found to be inadmissible on grounds of security, violating human or international rights, serious criminality, or organized criminality. So serious criminality must be with respect to a crime that was punished in Canada by a term of imprisonment of at least 6 months. And in the next slide, we'll go over what serious criminality is very briefly. So a PR holder or a foreign national is inadmissible on grounds of serious criminality for being convicted in Canada of an offense which is punishable by a maximum term of 10 years imprisonment, or of an offense where a term of imprisonment of more than 6 months has been imposed, or for serious criminality for being convicted of an offense outside Canada, that if it was committed in Canada would be punishable by a maximum term of 10 years, or committing an act outside Canada that is an offense in the place where it was committed, and that if committed in Canada would be an offense punishable by a maximum term of imprisonment of at least 10 years. We'll go to the next slide. So, if you were convicted of an offense outside Canada that if committed in Canada would be an indictable offense punishable by a maximum term of imprisonment of at least 10 years, you're deemed rehabilitated at least 10 years after the completion of the sentence imposed, or you're eligible to apply for rehabilitation 5 years after the completion of your sentence. If the offense is one that would in Canada be prosecuted summarily, or if you were convicted for 2 or more such offenses, the period for rehabilitation is at least 5 years after the sentences imposed were served or are to be served. So these are some things to consider when you're helping or representing a client who has a criminal record in Canada or outside of Canada, and they're also an immigrant. That's it. So it is very important when you're assisting clients, like Rowan and I have both sort of mentioned before, to identify immigration issues as early as possible, because there are deadlines that need to be met for any rehabilitation or renewal of permits, applications, status. Make sure that if you're serving in these areas of law, you have immigration questions in your intake procedures, just so you can determine if they need help from an immigration lawyer. And of course, all of us lawyers need to work together, and feel free to reach out to us at Fisher Law or to me directly if you would like to speak to our team, and we're very happy to assist you. Thank you.
Thank you very much, Amna and Rowan. I can report that there are no questions at the moment in the chat room, but I have a few questions for you. And I'll go back to Rowan for a moment. And Rowan, has there been any recent announcements or consultations by the Federal Minister of Immigration that would impinge upon anything that has been covered today?
The announcements are ongoing in immigration. There are announcements every week which change dramatically, either programs themselves, initiate new programs, cancel programs almost overnight. There are also ongoing announcements with regards to forms and what forms need to be used or not used. And applications can be refused if the wrong forms or the wrong generation of form is used. So recent immigration announcements federally have included all kinds of new programs. That's really the big push at the moment for the federal government, is to put forward new streams that are very specific because they're really hunting for people in different industries. So they just initiated a new medical stream for people who are coming in medical fields, whether that's nursing, doctors, physios, all kinds of people in medical and health fields. So there's a specific stream now you can apply as one of those workers. Transportation is another big one as well. So any kind of drivers of any kind, particularly, the entire country is desperate for drivers. And so the federal government has recently recognized that and put together a new program for that. Regionally, provinces, every province has its own subsection area that they have jurisdiction over within the immigration sphere. So each province then continually, in each territory, then continually can change and adapt what they have jurisdiction over. Some things that have happened recently are things to do with technology, for example. When you're looking at the Yukon immigration programs, they have implemented very specific preferred industries where those applications will be recognized and prioritized first. So when we're working with clients from the Yukon, of course, the first thing we do is we look at what are the most recent updates. Are there any changes to that list, both the eligibility or occupations and demand lists, or whether there are actually additions to the ineligible list, because that changes as well. And those impact both employers and employees. So the Yukon needs certain kinds of workers, but also only certain kinds of employers are going to be eligible for those business immigration programs in the Yukon.
Well, speaking of Yukon, and I'll put this question to both of you, Amna or Rowan, do you have a sense of the numbers in the Yukon? And by that, I mean, how many people are in the temporary foreign worker program, or how many permanent residents are there? What about the international mobility program, the Yukon nominee program? Do you have a sense of numbers? I ask because, as you just alluded, Yukon has Canada's tightest labor market. We have month in and month out one of the lowest rates of unemployment currently. As of the last statistics from Statistics Canada a month ago, the lowest unemployment rate in Canada, which means virtually everybody that can work is working. So tell me about the numbers, if you can, in these different programs.
Sure. So those are all very different numbers that you're asking about. Those are about 9 different statistical data points. So we won't go through all of those, but what we can do is say there has been at least and over 100% increase or more of immigrants coming into the Yukon. And that's been in the past 2 years. So there is a significant, and our employer clients are recognizing it. Our individual worker clients are recognizing it. And also, just culturally in the Yukon, you can see things changing. There are mosques and there are temples and there are gatherings and cultural gatherings and all of those things that are directly impacting. As you said, the best place to get statistics for all of those programs you mentioned is Statistics Canada. They have an exceptionally good website that you can type in whatever criteria you are looking for specifically. If it's Yukon specific for any of the many programs for the Yukon, if it's federally, there's lots and lots of information there. So I won't go through all those numbers today, but there is definitely information out there for those people who are interested through StatsCan that are very specific to the Yukon. And there has been a dramatic increase in all areas, in all programs. There's no program that hasn't been touched by the influx of immigrants at the moment.
Okay, so given what you've just said, Rowan, Amna, I have a question for you. Uh, where are people getting there? We've got a lot of immigrants here in Whitehorse. Walk down the street, look in your workplace. I work at the city of Whitehorse part-time, and I work with a team of people are from all over the world. So Amna, where are Whitehorse folks getting advice, or are they getting advice about immigration law?
Yeah, I think part of the reason that we wanted to sort of expand fisher law into the Yukon and start with this sort of pilot program to provide free immigration advice and consultation was to gauge whether there is a need for it to begin with. And my understanding from having been doing these sessions since July is that people have been usually going to consultants. They're also getting some information from the Multicultural Center, who are now, when it is a legal advice matter, refer a lot of folks to us to see me for consultations. But there has been, as far as I understand, a gap. Like, it is an underserviced area of law in the Yukon, which sort of triggered me when I was looking for more sort of litigation-sided work to reach out to Rowan and be like, hey, I think no one here is giving legal advice to immigrants or immigration or refugee law. And so let's see if people need help with that. And like I said, my understanding is that before that, there weren't, before us providing this advice, I don't think people had a lot of reliable sources.
Well, just a follow-up, Amna, to what you just said. Are there immigration consultants in Whitehorse, in Yukon? And is there one or two or quite a few? And what kind of hat do they wear? And are they immigration consultants or immigration consultants / lawyers? Can you speak to that?
I've heard that there are a few. I don't know of them. I've never gone looking for them. I think that if they are advertising that they're consultants, they need to be certified to be consultants. But I've never met one or been contacted by one, really.
So I have encountered a couple immigration consultants who work in very specific areas. So immigration consultants often specialize and work only within certain areas of immigration law. And I've met, like Amna said, a couple, and that is all. And we have not met any immigration lawyers. And that was when Amna reached out to me and she was like, hey, there's no legal representation. And it's part of the reason why we started the clinic as well, is that there was nowhere for people to be able to book an appointment just to get even summary advice, like just to get basic advice on their situation so that they can take the next steps forwards. That was part of the big impetus that Amna really put forward, was like, there's no one here for people to just talk to someone and get an idea of even resources. So we really wanted to fill that gap. And so that was a big reason why we started the clinic.
Rowan, a question for you. This is more national in scope. As you well know, Quebec government has had a Ministry of Immigration for a long time, notwithstanding that immigration is largely a federal responsibility. And for about 10 years, the province of Nova Scotia has also had a Ministry of Immigration. A question I have for you is that a benefit or a hindrance to the practice and the advice giving in the world of immigration law?
We find it, so we have an immigration ministry as well. It's combined with other ministries in Alberta.
Okay.
And many provinces have immigration ministries. And we find that very useful to have access, especially in my role as the chair of the immigration bar in Southern Alberta, to be able to have access to a team of people who are in the designing, or who have phone numbers, who have emails, who are involved in putting programs together, in evaluating programs, in looking at the future and what programs are needed. we can really work as an immigration bar with that ministry. So we find that quite useful. It depends on the ministry, how effective it is. And of course, it's going to depend on the red tape and who's available to speak to you, how interested the people involved in that ministry are. Often if they have an immigration lens or immigration experience themselves personally or their families, we find their understanding of the process and the necessities, wonderful. And then in Alberta, there's also all kinds of subdivisions within that ministry. There are people who actually run the Alberta immigration program. And so that's a whole group of other civil servants that we also have access to. So although the ministry sometimes can be a bit of a barrier if there's problems with red tape and communication, like anything political, it can be a wonderful force to be able to have somewhere to lobby, to be able to pitch our ideas as a bar as to, what could be going on forward. It also helps our clients, especially our corporate clients, in different industries. So when we work with people like the Calgary Construction Association or chat with the Calgary Hotel Association, those umbrella organizations have somewhere to lobby to really have their industries, especially during the current labor shortages, heard. So we find it more useful than not at the moment. But again, I think it probably depends on the region you're in.
Okay, we have a comment from the chat room. I'm going to read it out, okay? So just bear with me. The font is quite small, so just give me a second here. One of the participants writes to say, I am a lawyer in the Yukon and serving lots of immigrants here. But you are right. I guess there is only around 2 consultants here, but never met one. There you go. One of
Well,
today's.
I'm glad we're not far off then, because Amna's done lots of outreach and has been to many events and connects quite a lot in community. And so we do know there's a few. I have definitely communicated with 1 or 2, but that is it. Great.
I do want to note, Rod, I don't think I was aware that you were providing immigration services in the territory, and it is great that you have been, and I would love to connect with you and have a chat.
It's nice to see you here, Rod. I'm glad you've decided to pursue this, because I know when we met in the Yukon in March, you were looking at and helping a few clients. I think you were thinking about doing more immigration. So I'm very happy that's working out for you. That's wonderful. That's great.
Okay, so we don't have any more questions in the chat room, and I'm just going to ask our presenters, Rowan and Amna, if they have any sort of concluding remarks or thoughts before we move towards ending today's session.
Here, Amna, why don't you go first from your white horse lens?
I was just gonna say that I have added more free consultation sessions that I'm doing out of the Legal Aid Clinic, Leslie McCullough's office, on Mondays, and that is due to people reaching out and wanting to meet a lawyer for immigration matters, and hopefully we can expand that into the next year as well and continue to provide these services, and hopefully provide these services and get compensated, because right now it's pro bono. So we're working here, we are here, and I would love to connect with other lawyers in the territory. And like this entire presentation was about intersection of laws, and there's always intersection. And I would love to connect with other lawyers and discuss any clients that they're serving who may have immigration issues, or if they just want additional information. We have a lot of info sheets. So yeah, just feel free to shoot us an email, and hopefully we can all help all these immigrants coming into the Yukon moving forward.
That's lovely. Thank you, Amna. And I think it is really important to build those connections and build those new networks. We do that in many regions across the country, to try and work with the criminal bar, with family bar, with business and employment, to try and support whatever it is with your clients going forward that you might need assistance with. And I think, making sure that at the beginning, if you could add a few questions to your intake questionnaires, for those of you who use standardized intake questionnaires, with regards to, if you have a place of birth question, that's obviously a good indicator that someone might be an immigrant. You can even add a question, something like, are there any immigration issues that we should be aware of at this time? Or do you have any immigration issues? Full stop, right? Just adding that into the intake really, really helps catch these things early. And the earlier we catch it, the better things and the better the outcome can be for your client. So thank you for having us here. We've really enjoyed connecting with you all. Thank you.
Well, on behalf of all the participants, I'd like to thank each of you, Rowan and Emma, for presenting today and just raising our awareness a little bit. I'd like to thank the Law Society's Professional Development Committee, because after all, they're the ones that produce and arrange for these. And I'd also like to thank the Law Society staff who help greatly with the organization of this event and other events, and for the technical support. I'd like to thank all the participants who were here today, and don't forget to keep an eye on the Law Society website for other upcoming webinars, because there are others coming your way. Just before I go, and perhaps to end on a somewhat sober note, I'd be remiss in not saying that December 6th is a special day in Canada, the National Day of Remembrance and Action on Violence Against Women. And like many of you, I was shocked on this day in 1989 when 14 women lost their lives and another 14 were injured. And so I know that across the country, and certainly in Whitehorse, there's commemorations that are going on. But with that, thank you very much to all.
I just want to thank you, Tom, again, for your continued support and for being such a good co-presenter, and of course the Law Society as well.
Take care.